So the court is moving this to give essentially an advantage to the other side. So that's, I'm making my record.
Recess. Okay. The issue has come up regarding this new report. As I would if people came up with additional evidence and the defense were in a position to potentially not be prepared to address it, I would adjourn it out. And I think only in fairness can I do that here. To adjourn these proceedings, allow them to analyze the information that's been presented to them, and then formulate what may be redirect, quite frankly, of Detective Parvis if necessary. So I analyzed it in my head in a lot of different ways. I'll say this, it's not necessarily any of my business. I'm also concerned because typically with experts and other types of witnesses, those derive from counsel doing that. And it's clear to me that this did not derive from counsel, which I think also causes at least some pause in terms of that, because I don't frankly know, and I'm not asking whether or not counsel, because he's the one that has to make the representations to the court and to other things, has had his adequate opportunity to vet what's there. So that is also a concern of mine.
Sorry, I didn't hear the last part, Your Honor. I apologize. I didn't hear that last part. You're concerned that I didn't do what?
To vet what's there. The timing of all of it is very odd to me.
Okay, yeah.
Okay, and so
okay.
That's also a concern for the court, in fairness to the defense, in terms of the questioning. So, I mean, there's a lot that's kind of going on here. And so from my standpoint, I'm going to take the approach, while it certainly may delay the proceedings, I'm going to do my best to try to make sure that it's fair. So
can I be heard just to make my objection for the record? For the record, this adjournment is over my client's objection, and I want to say
what's the basis of the objection?
Sorry?
What's the basis?
Her objection is her Sixth Amendment right to cross-examine and confront the witness against her.
That is not being kept quiet.
Okay. Sorry. I'll let you finish. Let me know when I can talk, because I just want to make a record. I will.
Yeah, but you're making a record of things that don't exist.
Okay. But
are you indicating that the court is taking away her Sixth Amendment right to cross-examine this witness?
I'm indicating that by essentially sua sponte moving this proceeding, the court is intervening and moving this hearing in a case where I was not going to even introduce the expert's testimony or his report. So the court is moving this to give essentially an advantage to the other side. So that's, I'm making my record.
Recess. Back on the record in the case of the People's State of Michigan versus Julian Carey. Counsel, you wanted to place stuff on the record. Go ahead.
Yes, sir. I'm sorry. I just wanted to say for the record that this particular case, I think that the adjournment infringes upon my client's rights under the 6th and 14th Amendment. The 6th Amendment being her right to confront and cross-examine accusers against her without any intervention by the court. And the other one would be the 14th Amendment right of due process for the court not to be fair and impartial. Those two, I just want to put those on the record, Your Honor, and I'm not trying to be adversarial. Thank you.
I don't need a response from people in terms of that. I noticed that you're noticing that for the record. So first of all, before I left the bench, you incorrectly asserted that the court is adjourning these proceedings sua sponte. This adjournment is after due consideration by the court based upon the prosecutor's request to do that. That is not sua sponte, and I'm sure that you would understand that being a lawyer, that it was not the court's, it's the court's decision, but it was not the court's motion to do it. So that's the first error that you made. There is no violation of defendant's Sixth Amendment rights in this case because the court is not interfering in the right to cross-examine. The court is going to permit effective cross-examination to the extent you can be effective of the witness at a later date. There is no interference. This delay in these proceedings has no effect on that whatsoever. I don't even know how you bottle that up to try to say in some way this court is interfering with her Sixth Amendment right to confrontation and cross-examination of the witnesses. Further, in regard to, and I assume as an attorney, you know what due process means, and that means that the court has to be fair to all parties, not just to you, not just to give some benefit to defense. The court considered everything that was raised my own questions about the new report, whether or not that would be prejudicial to the people, whether or not it'd be prejudicial to the defense, weighed that, went back, took time, looked at it, would prefer to go today. Set aside the time at your request, counsel, from the last hearing, that I have a blanket time so that it wasn't with other cases to hear it. I've set aside the time to do it. That's part of due process. Part of due process also is making sure that each side has a fair and adequate opportunity to do what they need to do in this case. It has. Now, those are the legal issues. What incensed this court, quite frankly, because it's something that I take very seriously, is the notion that this court has done anything, ever. And in my 25, almost 26 years, I've never been accused of that. Nobody has said that I have done anything to give one side an advantage over the other. It is not me. And I think, counsel, as you've proceeded through this case, you have seen that. I have never done anything that has said that people are going to have this advantage or to the people that you're going to have this advantage. I call it straight down the line. You get to present your case. I make my ruling. That's how I work. That's how I've always worked. So I will tell you that this court takes great offense when there is any indication that that's what this court is doing, that this court has any untoward motivation in doing what it's doing. That's my record.
You want to respond to that?
At your own peril, counsel.
And to say, I appreciate the court finding that today, no other cases. I think that I really appreciated that. That's why I wanted to get this on today. I mean, I think that if there were a legal reason for the court to put it over, then I would understand it. I just don't know what the legal reason is, since the
legal reason is exactly what you brought up: due process and fairness to the parties. Prosecutor raised an issue. I've gone through that, counsel.
Okay, I'm done.
Is there anything else you want to say besides trying to waste my time?
I'm not trying to waste your time. I have nothing else to say. Thank you, Your Honor.
Preliminary examination in this matter will be adjourned. August 12, 2025, 2 p.m. That's before me. We will go that day, folks. Even if we have to be here all evening, we will go.
In a tense courtroom moment, a routine hearing suddenly turns into a heated legal debate. The issue begins when a new report is brought into the case. Because the defense has not had enough time to review the information, the judge considers delaying the proceedings to ensure fairness. From the court's perspective, the goal is simple. Both sides must have a fair opportunity to analyze the evidence before continuing. But the defense attorney strongly objects. The lawyer argues that delaying the hearing could violate the defendant's constitutional rights, specifically the Sixth Amendment, right to confront witnesses, and the 14th Amendment right to due process. As the attorney places these objections on the record, the judge begins to respond, and the tone in the courtroom shifts. The judge explains that the adjournment was not done arbitrarily. Instead, it was based on the prosecutor's request and the court's responsibility to ensure a fair process for both sides. Then the judge addresses the accusation more directly. He firmly states that delaying the hearing does not prevent cross-examination and does not violate the defendant's rights. In fact, the delay is meant to give both parties enough time to properly prepare. But what really stands out is the judge's reaction to the suggestion of bias. Clearly frustrated, the judge says that in nearly 26 years on the bench, no one has ever accused him of giving one side an advantage over the other. He emphasizes that his role is to call the case fairly, allow each side to present its arguments, and then make a ruling based on the law. In the end, despite the objection from the defense, the judge makes his decision. The preliminary examination is officially adjourned and rescheduled for a later date. The courtroom may have calmed down, but the tension from this exchange leaves a lasting impression on everyone in the room.